Morning.
Yeah, pleasure to meet you. How you doing? Yeah. Yeah. So, yeah, just how you doing?
Yeah, we're
Yep.
I saw it. You can always check this.
Yeah. So,
Oh, okay.
I just can't get them. They're afraid. They're afraid that they're going to get under. And I'm like. Hi, good to go.
Is that a requirement? Oh, yeah.
so you know, like.
It's 2 o'clock too.
So,
No.
Hey, very good.
Yeah.
No, I really like it. So, yeah, no worries whatsoever. He's trying to bring us, and he can. I mean, what's that at all? I'm like, oh. Which I haven't heard that term. Is it blanket? So, yeah, it's a whole. Yeah. What time is it?
Just you're thinking that's kind of like.
You guys, a breakdown?
Yeah, there's somewhat of an outline. Try to keep as dry a topic interesting as we can.
Haggard, real estate. Firms,
Oh, yeah. Yes.
So yeah, I'm gonna interview you guys, maybe ask some questions and I go.
Yeah.
Realtors, dude, always showing up.
Yeah, I was gonna say, I'm
3 to 5 minutes late.
Always.
Always shows, right? You always gotta start fast at 2:05.
That's right. It works. No cocktails or anything?
I thought you were bringing it.
Yeah.
I thought that's why we were here.
Oh, they used to take.
They're talking about Will with some drinks in her hands.
I didn't know you were doing that.
I just found out though. So.
I know what it was, but I don't know. Nice to see you.
This is Justin Ball. Nice to meet you, Justin Pilchman. That's Justin Pilchman. Pilchman.
Are you guys?
Yeah, we're colleagues. Yeah. Looks like a whole new players. Too many Justins in the room.
All right, guys, we'll get started because we only got them for an hour. I'm sure you guys got a lot of questions. This is Keith Brown and his associate Justin Pilchman. And Keith has done a bunch of work for me personally. I know a lot of people in this room already know him, Stuckert and Gates. He's been around forever, right?
Just about.
And
Over 100 years.
over 100 years. So there you go. I'll tell you, Keith has been a great resource for us, and a lot of other attorneys that we deal with on the other side know them as well. So when you're trying to get something figured out, that goes a long, long way. It's like working with a really great co-op that you already know from deals in the past. So they have an outline of what they want to go over, but any questions, it's totally open forum, right? They can shoot whatever you want. There's going to be a lot of stuff covered, and it's up to you guys if you need, if you can continue for a few minutes afterwards, and that's all good. But yeah, I mean, we can just fire away. Do you guys, does anyone have anything off the top that they want to get to right away? So to make sure like it's urgent or anything that, I know it's a lot of things. It's wills, it's life insurance stuff, all these questions. But if not, you can just, you can sort of get started. I'll slide out here.
And how best to leave the stuff to the kids, do it before or after, basically, the gist of it. right?
What do you
For
say?
your estate.
Oh, for the estate, what to do? Yeah.
We're definitely going to talk about it. Thank you for getting that up too. Well, thanks for inviting us. It's nice to be here. Justin and I have talked about
kind of going back and forth. So we're going to both be saying things about estate planning because it's kind of informal and we'd like it to be that way. Just even though we're standing up here and you're sitting there, feel free to just put your hand up or let us know somehow, look interested, and then we'll know, okay, you got a question. We'll try to stop and make sure we touch on it. So one of the things that we want to make sure that we cover with you is that good estate planning is a process and it involves flexibility. So in the outline, you'll see it talks about flexibility as being kind of the building block of a good estate plan. Just to kind of cover the basics, essentially in most estate plans, you're talking about doing a will, a financial power of attorney, and a medical power of attorney. There are a lot of times other documents come into play, but those are kind of the basic building blocks for an estate plan. Well, what a lot of people think, and this is easy to do, is I got it done, I put it on the shelf, I'm good. That's the end. But actually, what we recommend to people is every 3 to 5 years, look over all your documents because things change and you forget. Oh, that's right. I named my Aunt Matilda and she's moved to Florida, and she's not going to be the right person to do X, Y, Z, whatever it is. So keep that in mind. Flexibility is something you need to build into a good estate plan. Most people also say, I think I know exactly what I need to do. I'm just going to tell the lawyer. Better to have one of those teachable attitudes when you go to see an attorney, because there's a whole lot of stuff that we will just touch on kind of the mountaintops today. And if you want to ski down a couple of them, we'll do that. But generally speaking, we're just going to touch on some highlights. So if you want to talk about specifics, we'll do that. But we'll probably do that with you individually, either in our office or maybe just sticking around after the time today. So Justin's going to talk a little bit about what an ideal estate plan involves.
Yeah, so let's talk about what the concept of estate planning is. It's really for planning for situations that arise later on in life while you are currently competent and able to make those decisions for yourself, right? Because we don't want to leave loved ones in a position where they have to make decisions for us or they have to get a court approval to make decisions for us. So when we talk about an ideal estate plan, it's really comprised of mostly 4 documents: the will, the medical and financial powers of attorney, and advanced healthcare directive. The powers of attorney are really talking about having somebody step into your shoes if you're unable to make decisions for yourself. And unfortunately, Keith and I see a lot of situations where individuals don't have those documents in place, and then we have to go to court and have somebody appointed when executing that document in our office. Is very simple. So the ideal estate plan will have your powers of attorney and your will in place, the disposition of your assets, because otherwise it's going to be regulated by the state, and the state basically says, well, this individual died, here are the family members that they have, and here's how the state says they have to be allocated. So when we talk about an ideal estate plan, it's decisions that you make now with your spouse or on your own, while you're competent, while you're able to make those decisions and doing it in a comfortable environment, like our office.
One thing to keep in mind is that if you think in terms of not writing these things down, you're basically saying to the people that you would want to either take over or who are your loved ones, there's no script, get on the stage and start ad-libbing. Okay, because that's essentially what's going to happen. They'll have to get court approval for a lot of things that they're doing, as Justin just said, and they'll have to try to figure out what maybe you wanted to do. They'll try to guess why you co-owned this one account with so-and-so. A lot of times they'll come up with maybe the wrong conclusions or imperfect conclusions. So what you want to do is write the script, make sure you put it in writing, then there aren't any questions about exactly what you meant. And of course, it's our job to make sure that we put it in a clear manner so that everybody understands, okay, this is what's supposed to happen. Here's the way the script works.
And that they're executed properly, right? A lot of people who come to our office say, well, hey, why am I paying an attorney to do this when I see some forms online that I can take care of? Well, part of executing your estate plan is executing it properly and with the proper formalities that are recognized by the state, to make sure that there isn't going to be some contest down the line where a relatively inexpensive problem now becomes a really expensive problem, right?
To give a good illustration of that and to kind of bring it home, you know what can go wrong with a real estate agreement of sale or other documents. It's not in writing. It's hard to guess at what's supposed to be going on. So same principle applies. We thought we'd kind of run through a bunch of mistakes that sometimes people make in estate planning and just talk about them. Again, just touching on some mountain peaks. One is, and it's a big one, dying without a will. We've already alluded to how you need to have a will in place. People sometimes think, well, I have a will and I took care of my spouse. I had a couple kids since then, but I think I'm fine. Well, the problem is you can sometimes create what's called a partial intestacy, which means I have a will, but it provides for my spouse and they predeceased me. So actually, I didn't do anything for my kids. And so you really have a will that's not covering the basis as it should. Go ahead, Justin, you want to do next one?
Yeah, and part of that not having a will is also, like I said, not having your other estate planning documents in place. Because if you don't have a power of attorney and somebody has to make decisions for you, we have to appoint a guardian for you. And that whole process takes several months, costs several thousands of dollars, where again, you could just execute that document, in our office. And a lot of times, if we rely solely on the will, and this is why having an in-depth conversation with an attorney and recognizing what all your assets are is important, because if we don't cover those assets, even if it's on a general basis, we create that partial intestacy and we have kind of an incomplete will that's not covering all these items. Or if you have some kind of life event that would change the construction of your will, like a marriage or a divorce, or having more children, or losing a family member, if we don't continue to keep looking at these documents, we're going to not account for certain contingencies that happen in all of our lives.
Another really important detail is making sure you've titled assets properly. And so it's easy to say, these are my assets, they're titled in my name, and forget about what I have jointly owned with my spouse or my second cousin, or a lot of times parents will put their children on as co-owners on an account. Forget they did that, and then what happens is they pass away, and those children get more money than the rest because they were co-owners. Nobody knows that they actually wanted it to go to all the children. Creating your own will, is that a good idea? As Justin just said, you can get on the internet, and I'm sure you've seen this. People can do all kinds of things on the internet. They can try to buy or sell real estate on the internet, that kind of thing. So I wouldn't recommend using an online form, but they are good in getting you kind of thinking about the right things. But that's why we have these estate planning questionnaires that I handed out. So you can get one, make sure you get one before you go. Those questionnaires are just 2 pages worth of questions and things to think about. And quite frankly, everything that you would probably need to think about with regard to an estate plan is at least touched on there. So rather than trying to create your own will, talk to an attorney and get all the details taken care of.
Yeah, and with that is also the idea of recognizing what would be covered under the will versus what is not, right? So when we talk about assets, we talk about probate and non-probate assets, right? The probate assets are those that are covered by the will. So those are assets that don't have named beneficiaries. Those are tangible personal property. It can be real estate if the real estate is owned individually. If the real estate's owned as joint tenants with right of survivorship, then it automatically passes to the other, or by tenants by the entirety, it would pass to the spouse. So with that questionnaire, we get an idea of what these assets are, if they have named beneficiaries, or if we need to name beneficiaries, and how that works in conjunction with your will. So part of estate planning is not only what you do with our office, but it may be contacting your financial advisor and working with them to make sure that everything's kind of online. Because Keith may or may not have touched on this, but sometimes these are delicate conversations and conversations that people don't want to have, especially when they're healthy and young and feeling good. But they're important conversations to have at those times so that it doesn't become dire down the road.
Let's talk about fiduciaries for a minute. You've probably heard the term in our world. What a fiduciary is somebody who's going to serve in high level of trust capacity, whether it's an executor, probably heard that term before, or it might be a power of attorney. It could be a trustee. Any one of those different roles is called a fiduciary role, which means there's a high level of trust and, of course, a high degree of performance expected. you could forget to tell your fiduciary that you named them, and you could run into a real problem. In other words, you just assume that your uncle, who's a banker and lives around the corner, he's local. Of course, he'd be the right person, but he might not be because he doesn't want to do it or he doesn't have the time to do it. A lot of times, we'll sit down with the fiduciary and they'll say, "I don't know what my Aunt Matilda was thinking, but I can't do this for X, Y, and Z reasons." They'll a lot of times renounce, and then we'll have to go to level 2. And if there is no level 2, sometimes people only name one level of fiduciary. That can be a problem as well. So you want to make sure you have at least 1 or 2 backups. We always try to push for a few backups so that we always have enough layers of fiduciaries in case somebody can't serve.
Yeah, and with that is also the idea of leaving some kind of outdated will in place. And I kind of talked about that. If a life event happens, you get married or you get divorced and you don't update your estate plan, what are we looking at, right? What's going to happen by operation of law to some of the beneficiaries that you have? Or if a fiduciary of yours passes away, what we tell people is, take a look at your documents every 3 to 5 years, see what's changed, and we can always make amendments to it and kind of have this be a continuing document rather than saying, "Hey, I signed this, I'm done with it. Let's let it sit for the next 30, 40 years."
Another problem that people have is hiding their will. Now, it's understandable you want to keep it confidential. You might put something in your will that you really don't want anybody to know about, but hiding it's not a great idea. In fact, I can give you an example. It's going on right now. We probated a will from a man who set up his will in 2018. We found out after that he had done another will in 2019. And then we just found out today that he did one in 2020 as well. Didn't tell anybody. And he's hidden it because we can't find it. We just visited his safe deposit box. It's not there. So hiding a will too well is not a good idea. Make sure that your attorney knows where your will is. You may want to give it to them for safekeeping. That's what we typically do with our firm. We hold on to originals. But if you take the original, make sure somebody knows where you keep it. And we also tell people, and this kind of goes along with it, we'll talk about this a little more later, digital assets are a big deal nowadays. Knowing how to get onto your online accounts if you were to become incapacitated or pass away is a really important component of planning for the future.
Yeah, and I think part of what goes into the will is what's covered by certain expenses, right? And making sure that your funeral expenses and your last healthcare expenses are covered, kind of taken off the top of your estate. That way you're not making your loved ones have to foot those expenses. We also put tax provisions in there as well to make sure that the taxes come out of the estate so that your beneficiaries are not having to foot some large bill to then have to get reimbursed for it down the road. That way it can all just come out of the will and people can get reimbursed for those things.
We talk about taxes a lot when we sit down with clients because it's a big concern. Sometimes people will say to us, I have a lot of assets, but they're all in real estate. And that may be true for some of you. How am I going to pay with cash within 9 months, which is typically the deadline for all federal and state inheritance and estate taxes? That's a big deal, and it's important to provide for that and consider that when you put together your estate plan. Any questions up to this point? We'll keep going, but I just wanted to check. Yes.
Not to jump, and I don't even know if this is appropriate at this point in time, but are there times where there's contrasting wills? Husband, wife, they both pass an accident.
Good question. And I think I know where you're going at. What you're saying is, what if they say 2 different things and they both died at the same time? What do we do, right? First thing is, as attorneys, we make it a point to make sure that we don't have conflicts between wills, so we don't run into that situation. A lot of times we'll build a clause into the estate plan documents that says, if both of us die at the same time, then this is what you'll presume and figure out whose will is going to control. If we do have a conflict like that, sometimes it would come down to a court decision. So you wouldn't want that, obviously. And so that's a really good point. It's another mistake you could make.
Yeah, we do have a provision, sometimes it's called a catastrophic provision in our wills that says, hey, if this horrible event happens, here's how we want our estate distributed.
And that would reference in both.
Correct.
Exactly.
And we'd make sure if they're both our clients, we'd make sure that that's consistent in both of their documents.
Well,
And with it, that's a good point, actually. With that, the documents don't, so spouses, their documents don't actually have to be identical. They don't have to name the same people. A lot of times we have people who name, their siblings as fiduciaries, but they don't want to name their in-laws as fiduciaries, right? So they don't have to be mirror images of one another, even though often they are.
That's a good question. So another thing that sometimes will happen is people will put together their will, but then they'll set up all of their estate, all of their assets as joint ownership with, as we said, children or maybe somebody else in their family. The thinking is, well, that's going to make it convenient for that person. They can write checks for me. Especially we see this with older people who are just saying, I don't want to manage my own affairs anymore. I'll just put them on as a joint account holder. But the problem is you essentially empty the cookie jar because all those assets that you thought were going to pass evenly among all the beneficiaries now just go to that one person. Or maybe it's two people, but there's 5 kids and the other 3 are kind of left out in the cold. A lot of times what will happen is after someone passes away, the ones that benefited will do the right thing and they'll actually make sure that it gets split up even. Not always, and they don't have to. There's no legal duty.
Yeah, and another part of the estate plan is not only accounting for children, but also incapacitated individuals or potential incapacitated individuals, right? In the wills, we normally, if there's minor children involved, we'd normally name guardians of those children if mom and dad are not able, if their legal guardians are not able to serve in that capacity. But we also account for what are called special needs individuals or special needs trusts. So if an individual is collecting some kind of government assistance by virtue of them having a special needs, we want to make sure that their receipt of any kind of inheritance doesn't disqualify them from that government assistance. So we do put in provisions, and mostly all of our wills now have special needs trusts, even if there's not currently somebody with special needs involved in the family. We just want to make sure that that's all covered.
And the downside is if we leave the asset to them, they'll be able to use it, but they become immediately ineligible for that assistance and then they have to spend it all down. Instead, we want to make sure that they keep getting those benefits. Sometimes
Yes,
people,
David.
Quick question.
sure,
Dave Marcola, thank
Hi,
you for
Dave.
your support of the NBA. Ongoing.
Absolutely.
And Justin, thanks for being my attorney. So my question is, do you feel that everybody needs to have an estate plan? You say there are exceptions. And my question would be specific to my father believes he does not need one because he doesn't own assets, he rents, he's single, and I'm the only child.
Okay. What do you think, Justin?
I think everybody needs an estate plan. Does he have powers of attorney in place?
No, because who else is it going to be?
Well, it's not you by law, right?
Well, I need that and what would be
It is not you. You don't go to the bank and say, well, I'm his only son, so therefore I can make decisions for him, or go to his doctor and say, I'm his only son, I can make decisions for him. They're going to say, okay, well, let's see the medical and financial power of attorney that gives you that authority.
I'm just going to pull the plug.
Well, we can write that in there, Dave, if you'd like, but
It's
Well,
good.
I'm on his bank account, but I mean, I guess it's from a perspective of, is it a power of attorney that you need? Is it really an estate plan?
It's not just the financial part, it's medical part, like he's on life support and he doesn't have a will, like, right? That's where it gets
He
difficult.
needs a medical power of attorney.
Exactly.
Yeah, that's right.
Otherwise, I'll keep him bugging.
And if he don't have one, and who's responsible, his wife or his children, to make a decision then?
Is your father still there? Just to
Married,
use him
no.
as an example. Okay, so since he's not married, his wife wouldn't obviously apply. And you're thinking it, and his thinking is, well, I've got a son, he's going to be there for me. But not having it in writing really complicates people's lives. We have situations where people will say to us, I have teenage children that are about to go off to college. Some of you may have this situation, or they're already there. And they say, how am I going to be able to access their medical information, which I've done for the last 18 years? The answer is, you're not, unless you get a HIPAA waiver from them. So that's part of a good estate plan for the younger people. For an older person, it really makes sense for your father or for anybody else who has somebody in this situation who says, oh, I don't need any of that. Put a HIPAA waiver in place at least so that you can at least access their medical information and have an intelligent discussion with their doctors. That's important.
and Dave, what's the the minimal cost and the upfront of having him executed, you know, you could have the downfall of, all right, somebody comes out of the woodwork and challenges then the estate, because there's no will ever in place, and we're just having the state basically step in and say, all right, well, this is what we think he said,
I
right?
got a brother I don't know about.
Exactly.
Well,
Would be a first, yeah.
Technically,
There you go.
if all he has is a checking and savings account and he's renting, literally, that's all he had, and Dave's already joined on those. Besides the medical.
Here's,
So-
yeah, good question.
So that's a separate question of whether or not you need to go through probate, right? Probate is actually the step of taking the will to the court, proving that it's valid, and, you know, becoming the executor, because that's what happens when you
So
probate.
then if you die without a will, what does the court say?
You have to be appointed as the administrator. You have to get renunciations from anybody else who's entitled to be the administrator. But what your question was more of an analysis of, all right, do I really need to probate here? Or do I have an estate plan, which are two separate issues, right? The estate plan is necessary, the probate may or may not be, depending on what the assets look like when the individual passes away. Because if there's nothing to probate, or if there's no taxes involved, then
I mean, if it's just a simple checking account, and that's all he's living on.
And a lot of times what we'll say to people is, it's easy to assume that that's all there is.
Right.
I can't tell you how many times somebody's come to us and said, my parent just passed away. They just have these couple of checking accounts, and then 2 days later they say, oh, wait a second. Oh, we found this. Oh, you know, they own some stock and it was titled in just their name. Now we have to probate a will. And if they don't have a will because they didn't think they needed one, not a good idea.
I just recently had an estate that the individual died 36 years ago. They never opened the estate, and then the son found, through unclaimed property, found like $40,000 in some stocks and stuff. So we actually had to go to court, because there's a 21-year period where you can probate.
Okay.
After that, you need court approval. So we actually had to file a petition to open it up again, just to open it and then close it, because we had to get that $35,000. Otherwise, there's no other
So
way to
that
get
could
it.
be in that situation where he thinks, I'm just glad I have a checking account with my name on it and we're done, you know? and then-
Sure.
A similar situation with the petition for probate. A real estate agent recently referred someone to our firm who found out that their first husband, who had died catastrophically in a car accident, very young, about 30 years ago, had a piece of property, and it wasn't titled as husband and wife, so it didn't pass to the wife automatically. Instead, it was owned 50-50 as tenants in common. Well, that meant that he still had an interest, even though she thought he was long gone. He still had that interest, and we had to actually go to the court, get permission to probate that estate so that she could sell the real estate.
And by the way, is your father in New Jersey? Pennsylvania. Okay. So here's the other reason. If you were to administer his estate and he did not have a will, you would have to get bonded because you're out of state. Whereas if he had a will, you wouldn't have to be bonded. It would just be automatic.
That's a good point. So one of those things that a lot of times people do is failing to have those difficult or challenging conversations about healthcare. And what are my wishes? What would I like to have happen if I'm in a terminal condition? A lot of times it's something we shy away from. We as attorneys are used to working with people and talking about it. We'll be glad to help you with having that conversation. A lot of times people do bring us parents or relatives that are older, and they just haven't done anything yet, and they just need somebody to kind of help them through the discussion.
Yeah. One item that we talk about a lot with clients are certainly taxes. Inheritance tax in Pennsylvania and the federal estate tax. The federal estate tax, we don't normally have those discussions because, well, we have those discussions, but normally doesn't apply to our clients because right now those rates are what, 11.7 million right now for individuals, and I think it's 22.4 for married couples. But as far as state inheritance tax, when you're looking down the line, so to children, as between spouses, there are no estate taxes. But when you're talking about children, that's a 4.5% tax. Now, what a lot of people contact Keith and I'm sure you've gotten this more often than I have, but a lot of people will call and say, hey, you know, I'm giving everything to my daughter, but rather than her having to pay that 4.5%, why don't I just put her on the deed to my house, right? Because then when I pass away, the house automatically passes to that individual. Well, what they don't think of is the income tax implications and not getting that stepped up basis from when the individual passed away. And what that means is when somebody passes away and you inherit their property, you get the value of the property as of the date of their death, right? So if mom or dad purchased the home 30 years ago, they pass away, the child inherits it. Sure, they have to pay the 4.5% value of that asset, but they're getting that value as of August 17th, 2022, right? Versus if they had transferred that asset to that individual prior to their death, they're gonna have to recognize all that gain from 30 years ago and pay capital gains tax, which could be 20, 25% when they then go to sell that home. So we have those discussions with individuals because they don't think about it. And sometimes, unfortunately, they do it before they come to our office and we then have to fix a mistake. Yes,
Just a
John.
question, follow up on that. So in transferring real estate into a trust versus having it set up so it goes directly to kids,
Mhm.
step up basis, if you put it in the trust, do you lose the step up basis or do you get the step up basis when you pass away and the trust gets disseminated to kids?
It's a good question. If it's a living trust, a revocable trust, you get the step up. If you put it in as an irrevocable transfer into an irrevocable trust, it's like you gave it away. It's like you made that gift that Justin was just talking about, and you lose the step up. So you have to be careful about which kind of trust you're putting it in, but
And I
the
guess you
kind
can
you're
talk a little bit
describing,
about
Yeah,
trust.
so, but generally speaking, what you're saying, if you deed the house from you and your wife into the trust of you and your wife, and that's a revocable trust, then you would still get that stepped up basis when the second of you passes away.
good question. Let's see, ignoring your electronic assets is a common problem. We have an actual clause that we put in each of the wills and trusts that we write that says that anybody who's going to step into the role of executor is going to be able to access all of your online accounts. Pennsylvania has recently adopted the RLUIPA, and I don't know what that stands for, but it's a long acronym, but it basically means that fiduciaries are allowed to access your accounts, but only if it says so in your estate documents. So we make sure we put that in because you'd be amazed at how many things you have to get to when somebody passes away, and you can be locked out for a long time until you get court permission.
I think you're going to speak about this one here.
Yeah, failing to provide for your parents or children. And basically what happens is sometimes parents will go into a continuing care facility or they'll go into a nursing home or some other facility and their children will be asked to sign on as kind of a guarantor. And so if that happens, of course, you have to take that into consideration in doing estate planning. But also what happens is there's always a possibility that that person will be tapped to have to actually pay some of the parents' expenses. So be careful if your parent is going into that kind of care, that you read carefully what you're signing or what they're signing. If you sign as their power of attorney, make sure you indicate that you're signing in that capacity. Because if you just sign your name, sometimes you might actually be taking on their own obligations.
That's the same thing with real estate documents too. If you're selling it as an estate, if you have clients that are selling, that the house is in the name of an estate, make sure that they're signing it. John Iannarelli, executor of the estate of, right?
Basic follow-up question
Sure.
on the estates and the trust, what have you. So when you pass away and you have it in the trust and you don't necessarily want the kids to get all the money in the trust,
Sure.
but you want to set it up so they get a certain
Yeah.
amount each year. What's that called, number one? Is that a living trust or is there a different name for that?
So you can do it a couple different ways, John. You can, and what we often do is we will establish what's called a residuary trust. So a lot of times we have that exact situation where, at the time of signing the will, we have, a 6 and a 4-year-old, right? And we can establish a trust within the will itself or outside of the will that has provisions for caring for those children, right? We can say that the children get the income of the principal, for the duration of the trust itself, that certain sums can be used for their health, education, and maintenance. They have college bills, and then they can get outright distributions at certain ages. A lot of times we'll do, 26, 28, 30, or 25, 30, 35, however you want to set it up. And it can be distributions over time, but it can either be set up in the will as a residuary trust or a standalone trust, which we're going to talk about shortly.
Good question. And one of the things to think about is the state will provide a will and an estate plan for you. If you die without a will, they'll give everything to your kids at age 18. And that's not the ideal, obviously. So what this trust setup can do is give them time to kind of, as I say, grow into their wealth. Okay, they get more familiar with it. They get it in stages instead of all at once. Yeah. Well, we're going to talk about living trusts. Thank you for that segue. Living trusts have some myths associated with them, and there's some realities that we want to address as well. I'm just going to touch on the myths real quickly. A lot of times people think that if they create a living trust, and by a living trust, we just mean a document separate from a will that is a place where you can put assets. I like to describe it as a bucket just because it's easy to visualize it this way. It's like you create a new bucket and you put assets into that bucket. You can either do it while you're living, that's why it's called a living trust, or you can fund it after you pass away, and your will would say anything that I didn't put into my living trust while I was alive pours into it when I pass away. That's typically referred to as a pour over
Quick
will.
question on that. So transfer taxes, when you do that, they incur that?
No,
Okay.
no tax.
So long as it's
Are they
in,
retitled in the trust name versus if you had, say, in an LLC prior to that?
so be titled in the name of the trustees on behalf of the trust. So a lot of times we'll have spouses that it's in their name. They transfer it to the spouses as trustees of their joint trust.
And there's no transfer tax
Yeah.
at all, which is good. But people will sometimes think, okay, I can put assets into a living trust so that I can avoid taxes. Well, the taxes that they're thinking of are that federal estate tax we talked about a minute ago, or the Pennsylvania inheritance tax. They both apply even if your assets are in a living trust. So that myth is not true. Another one is that probate is something that you have to avoid at any cost. People will say to us, I want to create a living trust to avoid probate. You've probably heard there are some experts in this area that say you must avoid probate. The reason, and we tell our clients this, the reason is because there are certain states in our country where if you avoid probate, you avoid their state's taxing system. California is a good example. They only have a probate fee. So if you avoid probate, you avoid their tax. Pennsylvania has a probate fee and an inheritance tax. Probate fee is relatively small, and so avoiding probate really doesn't avoid a whole lot in the way of expenses. It doesn't avoid the taxes, we said. People will think that if you have a living trust, you don't need a will. Actually, you need both, because there's always a chance that you have an asset that you never put into that bucket. We want to have a funnel directed to that bucket, and that's the will, pour over will. It gets everything where it needs to be. And then another myth is your lawyer will try to talk you out of a living trust for their own selfish reasons. I'm not even going to go into, I've heard this from people, but basically what they're saying is you as an attorney won't get as much of a fee if I put my assets into a living trust. So you're going to try to talk me out of it. It's just the opposite. I try to explain to people why they don't need one. But if they say, I really want one anyway, or I grew up in California and I just have to have one, and I just feel like it's important, we'll create a living trust for someone. It doesn't hurt in any way, and sometimes it helps. And Justin's going to talk about some of the good reasons to have a living trust.
Yeah, one of the main reasons for our clients that we establish living trusts are when they own property outside of the state. So a lot of our clients will have a shore property. What happens if they pass away without a trust is not only do we have to, so Pennsylvania probate can only cover what's in Pennsylvania, right? The actual property that's in New Jersey has to go through what's called an ancillary, secondary probate in that county. So I had somebody recently passed away that had a house in Newtown and they had a house in Cape May County. We had to go through a probate in Bucks County and then transfer that probate into Cape May County, which ultimately wasn't that big of an issue, but you can avoid that by having a trust and naming the property into, putting both those properties into the trust. Another reason why people will establish a trust is they, as Keith was saying, sometimes they think that they're going to avoid the time that it takes to probate the will. Pennsylvania is not ultimately that long of a period. There's kind of a baked in period of time that the state has to approve any kind of inheritance tax anyway. That's about 4 to 6 months, which normally takes up the whole probate period of time anyway. So you get a little bit of an expedited probate by having a trust. Also, if there's any kind of fear that the will is going to be challenged in any way, the trust is a private document, whereas the will is public because it's in the register of wills at that point. So you have a little bit more privacy, and I think that's pretty much.
Those are the main
Yeah.
advantages. Sometimes people will say to us, I want to do a living trust because I'm just tired of managing my own financial affairs. And so, and a lot of times they'll be older clients in their 70s or 80s or 90s. And that makes a lot of sense because you can put assets into the trust and then just say to whoever that backup trustee that you named is, okay, I'm done, you take over now. Whenever that point comes, or sometimes it comes and they don't even realize it because they just lost their ability to think clearly. But now it's all in place and they just step right in. It's a smooth transition. That works really well. And speaking of smooth transitions, another reason to do a living trust is if you have a business interest and you can't afford for a 2-week gap where you've just passed away and the executor hasn't been appointed yet and there's nobody to step in and take over. There's a business that needs to run the next day when you've passed away. A living trust can give that smooth transition as well. So sometimes we'll set up a trust just because we know that somebody has that kind of business. And it's a good idea from that perspective. But we've been talking a lot. Why don't we give you guys a little chance to ask some questions, bring up situations. What I would recommend though, and this happens a lot of times, is when we talk about estate planning, you're probably thinking about your own personal estate plan. Don't give us specifics, just talk in generalities. And if you have a situation that you know about, but you don't know all the details, just wait until after we can talk about it.
Put Dave's situation to the side there.
Yeah, that's right. There you go. We already covered that one.
Hi. So the one thing that I feel like has come up throughout my real estate career is people that like their parents pass away, they didn't have a will, but there's a property and they don't know what to do. Like, what should I tell them that they need to do?
And the individual's already passed away. So they're gonna have to go through an intestacy procedure where they would have to hire an attorney or go to the Register of Wills and get appointed as the administrator of that estate to then handle that asset, because otherwise they don't have the ability to sell or transfer that asset without the court saying, hey, you can sell or transfer that asset.
A lot of times people think, oh, I'll just list the property, I'll come to the settlement with a death certificate and that's all I need. But they need to prove that they've got it already. Yeah.
So they need to go to the Register of Wills really to get
And follow
appointed.
those formalities, yeah.
How long does it take?
I mean, it depends on the situation. I mean, if you have a clean situation where there's only one person who would be able to serve as the administrator, it could take a few weeks. But if you have a situation where you need multiple renunciations from a lot of individuals who could serve in that capacity, then, you know, getting people to sign and notarize documents takes longer than you think.
We had this situation just 2 years ago. I had 17
Yeah.
heirs, all of whom had to sign off before we could get.
And they were all around the country
They were all
too,
over
yeah.
the place. Yeah.
And then try being the realtor, you know, knocking on our door saying, hey, what's going on with the state? And, you know, we're bleeding money, yeah. Yes.
So after that point, when there's an administrator, I actually have a client that's an administrator currently on his dad's property. Does he need to do anything with, because you mentioned inheritance tax and everything, how does he connect the dots with the state to make sure he pays those taxes?
That oftentimes comes up with the title company.
Okay.
Where they will say, well, did they pay the inheritance tax?
Right.
And that's court. So when you actually pay the inheritance tax, there's a notice of appraisement that says, hey, inheritance tax has been reviewed, been paid, or the title company will hold an escrow so that once the inheritance tax is paid, or they'll pay it directly. But
And that can be up to a year. Trust me.
yeah, I just had one released recently, and the title company will normally hold, you know, two times what the actual amount would be.
Yeah.
So,
Okay, so
Yeah.
what, would he have to go to, or tell the state that like, I'm selling my dad's house and then like, give me a tax bill, or how does he get the tax bill?
Good question.
Yeah.
So what happens is when we administer an estate, we put together a draft inheritance tax return, which is the form Rev 1500. It lists all the assets, all the deductions that are allowed, and then we come up with a net number, multiply it by the 4.5%, or if it's a different level beneficiary, it'll be a different tax rate. We come up with the bottom line, and then either if they have the funds, because there's money set aside, they use it to pay it.
Right.
And then we can prove that to the title company, or sometimes it's just, this is the only asset, we're selling it, so the title company holds, as Justin said, in escrow those funds.
And the title company may pay it, may pay it directly, or send us a check payable to the state for that amount.
Got it. So he should either set that up with an attorney
Mhm.
or an accountant, maybe, or no?
Typically it'd be an
yeah,
attorney, yeah.
Okay.
Right.
So I don't know if he did that step.
Sure, because our office does have paralegals, and we personally file
Because I
Rev
asked him,
1500s.
okay, because I asked him, did he use an attorney for the administrative? No. So, maybe we can talk in detail.
Yeah.
about
Sure,
that.
yeah. Yeah, because the other question that we would have is, when did the individual pass away? Is the value of that asset, it would be the value as of that time.
Oh, it was just this January,
Okay,
and it's closing this month.
got it.
So,
Sounds like something urgent, so.
yeah.
Got it.
Thanks.
Yeah, John.
The life insurance is gonna pass to the beneficiary outside of paying taxes.
It's a non-probate
Non-
asset.
yeah.
That's right.
So,
It's also non-taxable. Yeah.
right, so do you recommend keeping it out of the living trust? Or if you put it into the living trust, does it make it taxable?
Good question. So the answer is it doesn't change the nature of the tax. There is no tax on life insurance. It's an exception to all the other rules. Life insurance going into a living trust sometimes makes sense because if you have minor children or children that are in that 20 to 30s age and you have a trust set up to benefit them, if you give them all life insurance money, they might say, oh, I don't have to worry about that other stuff. I'm going to blow this money in. So instead, you may want to funnel it all to the same place. On the other hand, you may have an estate plan that says everything goes to all my children because they're all in their 30s and 40s and I'm fine with them getting it outright. Then you probably don't need to change the life insurance beneficiary, just keep it as the children. Secondary beneficiary is the children. Primary is the spouse and then the children.
But so if you make the trust the beneficiary, then it doesn't become taxable?
No.
So it's always not taxable.
Are you ever too young to have a will?
Good
If you're under
question.
18, yeah.
Yeah, you can't do it if you're under 18.
Oh, yeah.
But I've had clients in their 20s who come to me. I had a doctor who came to me. He just got out of medical school and he said, I want a living will. He knew why he needed that. But he said, I think I need some other things too. And I said, yeah, of course you do. I mean, you need to have that ability to control who's going to step in all those different fiduciary capacities. Nobody knows when they're going to become incapacitated or pass away for that matter.
And with that, I mean, the amount of guardianships that I've handled in the last year, I mean, I've had 24 maybe, just individuals who, a lot of times it'll be when parents are not able to make decisions and they never had a will. And now they're suffering from some kind of dementia or some kind of illness where they can't sign a power of attorney, and then we have to go to court, and it's really a painstaking process. It does take, I mean, we handle them, but it does take a lot of time and it's a lot more money. So these are some things that, a lot of times, unfortunately, in our practice, we see when people don't do it right, what happens on the other end, whether that be intestacy or these guardianship matters.
Which is why we're talking to you today.
Yeah.
Right?
Yeah, John.
Does it matter what state you create the living trust in? Is it a benefit to do it in Pennsylvania versus New Jersey or Florida or Delaware?
Yeah, good question.
I mean, it's going to be applicable in each state. I mean, obviously, each state has their own formalities and their own state laws, but I would do it in the state that you're currently residing in, certainly.
Even if you have properties outside that state as well? Or?
Yeah, that makes sense. Because if you're domiciled in Pennsylvania, for example, but you have a Florida property, you would want to move that Florida property into your Pennsylvania trust. I have clients who move to Florida, they change their domicile, and then they switch it. They have their Pennsylvania property that they put into their Florida living trust. You could do it either way, but it's wherever you're living and you're permanently residing at that time.
Right. It's obviously Florida from the state income tax is beneficial to have it, quote unquote, residents of Florida, but can you have residents in Florida, but still still have the Pennsylvania?
So it's a good question.
Trust?
I think your question is, if I'm domiciled in Florida, which is a legal term that means in Florida terms, it means I'm here for at least 6 months and a day every
Right.
year. Then what about my Pennsylvania connections, right? Isn't that what you're asking?
Yeah, and do you set your Pennsylvania, you set your living trust stuff as Pennsylvania, or would you put it in Florida?
We typically would recommend people use Florida because that's their domicile. Yeah, that would make sense.
In simplistic terms, you're talking about, let's say there's one parent left that owns the house, that has adult children, whether or not putting it in their name now as all, rights of survivorship or whatever, or
So,
leaving it in a will. What are the benefits?
so that's an analysis, like I said, that we take on a case-by-case basis, right? Because if they purchased that home 30 years ago, transferring that asset to themselves and the 3 children may not make sense, because when the children go to sell that house, they're gonna have to pay all the capital gains from 30 years ago, right? If it was a year ago, we may not be looking as so what we normally do is we actually have a little breakdown that we will run the property through, what the property is valued at now, what they purchased it then. We run it at 4.5%, right? What the inheritance tax would be, and we also run it at what the capital gains may be. And a lot of times it spits out a number, but generally speaking, most of the time we've done that for people. It makes sense that they inherit the property rather than transfer it. Yeah.
So if.
But not always. Every once in a
So
while,
if,
there's an
if,
exception.
if the one person's on it and they add the kids today, die next week, capital gains is just from when they added the kid or from when they originally purchased?
When they originally purchased it.
And by the way, if they
You're
die
not
next,
retitling
if
it.
they die next week,
Yeah.
they lose out on the inheritance tax too, because you have to live for a year after you make the transfer.
There's a look back period, yeah.
And you pay that capital gain even if you don't sell it, or only if you sell it? In that situation?
When you sell
When
it.
you sell it, yeah.
Okay.
It's your ordinary income tax rate, so it's on a marginal basis. So for a lot of people, it's 20 or 25, as Justin said. Some people it's 30 to 30s.
Could your parents sell you the property beforehand, and then that way you could avoid that capital gains?
If they sell it.
Yeah.
For fair market value, sure.
But then your parents may have to pay the capital. I mean, they could write off a lot of it, but they would have, so
Okay, so
subject to that as well.
it's based on fair market value, and they couldn't just sell it to you just for whatever amount.
Yeah, let's say that you had a property that was worth 300,000, and they sold it for 100,000. Well, they actually just made a gift of 200,000.
Oh,
And
that's,
so you'd end up paying capital gains on that, what wasn't actually,
okay.
that makes sense?
Mhm.
And don't forget, as Justin just said, everybody has a capital gains write-off of $250,000 if you're a US citizen, and you've resided in the property as your principal residence for 2 of the last 5 years. And a lot of people throw that away by giving it to their kids, when actually it makes more sense to sell it to some third party, or even sell it to the kids, because then they can write it off.
Mhm.
They can use that write-off. If there's husband and wife, it's $500,000. That's a nice savings on capital gains.
go ahead.
I was gonna say, are there any exemptions to that? Like if the child is incapacitated or anything like that? Are there any exemptions to the cap gains tax?
Good question. I don't think so. There are some exceptions to rules when there's somebody who's in a special needs category, but I don't think there'd be an exemption on that one.
Okay.
So why isn't it a gift when you sell a property under value to somebody?
It's a partial gift.
No, but I mean, like, so say I have a house and I sell it for 100,000, why isn't the 200 considered them a gift? I'm just-
Yeah.
It's an out there question,
Yeah.
it's just a real estate question.
So the special needs trust, does that sit within the living trust, or do you recommend that sit outside of the living?
A lot of times we just put it right in the will. Just like I was talking about the residuary trust. So the residuary trust I was talking about for the children, right, over periods of times, a lot of times we write that in the will. So that trust does not exist until the individual passes away. Then it's set up after the fact, right? Same thing with the special needs trust. If there is somebody who falls into that category, and we define that within the will itself, we would set up that special needs trust for that individual.
But to answer your question just a little further, there are occasions where we'll set up a special needs trust all by itself as a separate trust. The reason would typically be because the parents not only want to provide for that child, but there's an uncle over here who wants to make gifts. And that's the place where you can put it and know that he's not gonna disqualify that person.
But that's what I was asking you, because if you had like a life insurance policy going into the special needs trust over here, but then you had an inheritance coming as well, from that same person, would you put that in the living trust to go into the special needs trust? Or
And so the answer, the easy answer, and this is a good way for us to finish too, is that's something that we have to talk on an individual basis about. What are all the factors that are coming into play? We've done it both ways and for different reasons. It's a good question.
I just want to bring up something for the KW agents in here, because we've had this issue with people passing and our profit share system, that in your estate, in your will, it better be very specific of where your profit share goes. So, and we've had that very recently here with people who make good profit share who unfortunately passed away. So just keep that in mind when doing your wills, that it specifies, because some people, there's a beneficiary page you sign now, when you sign on as a KW agent, but they didn't have that some time ago. So you want to be very clear where that goes. There's a lot of money in that system. There's people in this, right here in this market center, make hundreds of thousands of dollars between our three, you know. So it's no joke money, and that's in perpetuity as long as the company's alive. So just something to keep in mind, if you guys are gonna put your wills together and all that, that, you know, it could be significant, or it could be this one we're dealing with now, it's like a few $100, $400 or $500 though, every single month to the widow. And it goes and goes and goes, and it can grow too. So anyway.
Good observation.
Yeah.
Absolutely. Yep. Well, okay, we probably should let you get going, but I can see some hands, so we'll talk with individuals afterwards. If anybody didn't get one of these questionnaires or the outline, I'm gonna leave them on the back table. You're welcome to pick one up.
And also certainly think of Keith and I, we don't just handle estate plans. I'm licensed in New Jersey. I've worked with some of the Jersey agents here on a lot of attorney reviews, and we handle real estate here in Jersey and anything that comes up, so. Yeah, yeah. Sure, yeah.
My question is, how often should you write your will, right? It's just, you make a will and then you stop. So that's where they were saying, look at it like every 3 to 5 years. To make it more sense. I had to go to my parents' meeting when I turned 18. They signed my brother. I signed the contract, and I think I signed one of those books too. They could access my medical records. My dad has never taken any type of legal. I should check, and because I want that, I still want them. I don't know. I'm sure Ryan probably gets that. Like, I don't want my mom to be looking at my more. That's funny. Thank you so much.
Have to see what he has. Have you seen what? Those are when you actually go to probate, or in this case, they give you a document to say,
It's not the same, but it's so it would apply to the house. And so what we have to do is provide for avoiding that tax.
Yeah.
Figure out the capital.
He wants to
In
do
other
this
words,
the right way. He has no idea.
Sure, so what may end up happening.
Do it all.
The inheritance tax is
Sean, do you have something that you?
9 months, and that would be September. I mean, even if you translate, it's really should be pay a little bit of policy.
But he would like to take care of it.
Does he have money? So
He's gonna make stuff.
sure, some people say, trust me, you need somebody to file the registry.
All right, I will.
All right. Yeah, good to see you.
And your name? Nice to meet you.
Run back on that.
years. Or, you know, that's, you know, just-
That's what the insistence.
whatever the value of it is.
Thank you.
We met before, right, yeah, a few years ago, yeah. Yeah. Maybe, show me like a record. Yeah. Yeah. Yeah.